Thank you all so much for coming this morning. My name's Tom Flynn, and it's a very great pleasure to welcome you all on my own behalf and on behalf of my co-organisers, Anya Deb, Katie Hayward and Ewan Smith, to today's conference on Parity of Esteem as a constitutional principle in Northern Ireland and beyond. The conference is funded by the British Academy, to whom we're very grateful, and it's hosted by our gracious hosts here at the Mitchell Institute, and it's been co-organised by my own institution, the University of Essex, and Queen's University Belfast. So we've a stellar lineup of speakers today and tomorrow, all of whom will be introduced in due course. But for now, it's my very great pleasure to introduce our keynote speaker to kick things off. Professor Christopher McCrudden needs no introduction, so I'll give him one anyway. He is Honorary Professor of Human Rights and Equality Law here at Queen's University Belfast. He is L. Bates Lee Global Professor of Law at the University of Michigan Law School. He's a Fellow here at the Mitchell Institute. He's a member of the Royal Irish Academy, a Fellow of the British Academy, a practising barrister attached to Blackstone Chambers in London, and he was most recently the editor of the Law and Practice of the Northern Ireland Protocol, published by the Cambridge University Press. His paper is entitled The Perils of Creative Ambiguity, Parity of Esteem in the Northern Ireland Peace Process. And so, Professor McCrudden, the floor is yours.
Thanks, Tom, and thank you for the introduction, and indeed for inviting me to speak today. So I should say that right at the beginning that this is the first time I've spoken about parity of esteem in any audience, and to be honest, until about maybe 4 or 5 weeks ago, when I was invited to give the keynote, I had never thought about parity of esteem. Never, once. So doing this keynote became quite an exciting, if rather tense, few weeks, when I then suddenly had to think about parity of esteem. And of course, one of the things that's clear is that parity of esteem seems to be making a comeback in Northern Ireland politics lately, with numerous examples of politicians recently invoking the concept, whether it's in the context of the petition of concern, principle of consent, flags and emblems, language issues, think Grand Central Station, Kemi Badenoch's comments with regard to kneecap, and so on. And not only in terms of political use of it, but also its academic half-life. So, just as an example, Padraig O'Malley's recent Perils and Prospects of United Ireland, interesting book, has something like 22 references to parity of esteem. So, to quote a famous saying, it's not going to go away, clearly, in the political context. So in the time available, and by the way, I have written a paper on this because I had to get my own thoughts sufficiently organized to be able to summarize them. There is a paper which I'm happy to give to anybody who's interested, and I'd be extremely grateful for any comments that you have on that. But in the time available, what I'll try to do is do something like 6 things. The first is to trace the origins of the concept in Northern Ireland in an attempt to pin down why it was introduced and what it was intended to achieve. And there's a kind of orthodox story, and I'll suggest that on the basis of archival research, that orthodox story now needs to be questioned. Second, hello, Brona. The second is I want to consider the extensive controversy around the use of the term, particularly in the early days. I'm thinking of now the 1990s. And that arises from various different uses of the term. Third, I want to try to detail briefly the use of parity of esteem after the conclusion of the agreement, so after 1998. Then I want to evaluate the current legal significance of the term I am a lawyer after all, I'm sorry. Both its legal status in judicial review, basically the answer is it doesn't have one very much. But more recently, the challenge that that's now going to pose in the context of the recent new language legislation, where it does now become a legal concept. And then fifthly, I want to consider the issue of constitutional principle, which of course is the framing concept for the conference today and tomorrow, and suggest ways of thinking about the notion of parity of esteem as a constitutional principle. And then lastly, I want to look more closely at the uses of parity of esteem and attempt to construct some sort of vague taxonomy of uses and characteristics. So that's my agenda for today. So let's start then with the origins. And the reason for looking at the origins is because depending on where you think it originated from affects what you think it was about. So Simon Lee has rightly pointed out, hello Simon, has rightly pointed out that one of the first uses of it was by David Blakely of the Northern Ireland Labour Party in, I think it was 75, in which it's basically used as a descriptor as to what the normative relationship should be between North and South. So the notion was, essentially, David Blakely's notion was, if Northern Ireland, particularly Unionists, are going to participate in all-Ireland institutions, then there should be, as he called it, parity of esteem between the two jurisdictions. There is an alternative version of it, of the story, which is that a long-forgotten liberal Tory politician called John Grigg actually used it in the context of East-West relations, where it was a question of, he conjured up, I think it was 1971, the idea in Encounter magazine, that famous CIA-sponsored publication. I think no implications there. But he conjured it up as basically an issue of how to reconcile relations between the United Kingdom and the Republic of Ireland, more generally, and which he proposed essentially what he called a kind of dual citizenship and, as he put it, parity of esteem between citizens and more particularly between the presidency in Ireland and the monarchy in the United Kingdom. So parity of esteem is sort of already there in the Northern Ireland context, whether it's Blakely or John Grigg. And then more recently, in the 1980s, before its more popular uses of it, the Northern Consensus Group used it in the context of internal Northern Ireland relationships. So this is all to say it was around in the 70s and the 80s, though rather sporadic and certainly unorganized and diverse. The key development that comes around is in the context of the Brooke-Mayhew talks. And by the way, in this context, I should say that, and I do this every time I speak, the Quill project, which many of you should be familiar with, which organizes materials with regard to the internal debates within government and between parties. That's an online archive in cooperation with Pembroke College, Oxford, and the Queen's Library here. That now provides an absolutely necessary source for anybody to look at anything that happens in the 1990s. So the story that emerges there is that, although, again, as Simon pointed out, it's used by the Standing Advisory Commission on Human Rights in 1990 in one of its reports, where it talks about equality of esteem, the real starting point is in the Brooke-Mayhew talks. And it's quite clear from that that the concept originated with the SDLP. So it's an SDLP concept which, and we can probably detail who precisely in the SDLP was responsible for it. And interestingly, one of the people who was responsible for it was a former teacher, whom some of you in the audience will know, and who probably brings it from the education context, where parity of esteem has long been used, since the 1940s at least, in the context of parity of esteem between different educational systems. For example, private, public, or more particularly, grammar, selective, and so on. So there is at least an inkling of it being related to the wider concept of parity of esteem. But once it's introduced by the SDLP and recognized by the governments as a critical concept, it loses any of that external connections and becomes a term of art in the Northern Ireland context. So then we have the Opsahl Commission and the Opsahl Commission report published in 1993. So notably, after it's first introduced in 1991 in the context of the Brooke-Mayhew talks, what Opsahl does is to popularize the term. So it doesn't originate there, despite the claims of some that it's Opsahl that originated it. I have to say, Simon, you did not claim that. You said that it popularized it, and that's, in my reading of it, that's absolutely right. But it had some effect in terms of it being introduced into the wider public political discourse. So we then have the term popularized, and it becomes initially a relatively uncontroversial concept. But that it loses its honeymoon sense pretty quickly. And I'll turn in a little to the criticisms of it and the controversy surrounding it. But despite the controversy, it's important that it not just gets used in the Brooke-Mayhew talks, it then gets transferred into the discussions over the Downing Street Declaration, the frameworks papers, in which it's included for the first time in a public acceptance of the term by the two governments, and then is adopted by both the British and Irish governments, notably in some speeches by Patrick Mayhew, and then gets transferred into the multi-party talks. All of it in that context, pretty uncontroversial. Everybody seems to be accepting it. And therefore, when it's put into the Mitchell draft, in the first Mitchell draft of the talk of the agreement in April, there is no attempt to take it out. So it gets passed into the Good Friday Agreement, where some say, or some have previously said, that's where it originated from. Of course, it's not originating in the Good Friday Agreement. The Good Friday Agreement confirms it. So in the agreement, then, there are 4 separate references to parity of esteem in somewhat different contexts. The first is the famous, the really important statement by the British, in the British-Irish agreement, that is the international agreement between the British and Irish governments, that the two governments commit to parity of esteem. Then there's a recognition under constitutional issues where the participants, that is the multi-party talks bit of the agreement, endorses that commitment by the British and Irish governments to parity of esteem. And then there's a separate, thirdly, a separate section of the agreement, which goes under the term of safeguards. This isn't the human rights part of it, it's the safeguards part of it, relating to legislative controls, where there's a statement that the Equality Commission could monitor a statutory obligation to promote equality of opportunity in specified areas. That later became Section 75 of the Northern Ireland Act, and parity of esteem between the two main communities, and to investigate individual complaints against public bodies. We'll see in a minute that the latter part does not happen. Finally, in terms of the agreement, the Northern Ireland Human Rights Commission, or what became the Northern Ireland Human Rights Commission, famously was mandated to advise the Secretary of State on a Bill of Rights, which would build on the principles of mutual respect for the identity and ethos of both communities and parity of esteem. So that's the agreement. Now, in terms of critiques, critiques start occurring really from about 1994 onwards, and get into a paroxysm of excitement around Drumcree in particular. So in terms of the criticisms, there are four broad criticisms, though these overlap from the unionist perspective, broadly unionist perspective. By the way, at the risk of stating the obvious, the unionist perspective here is a multitude of different understandings. And I'm not including, for example, loyalists within that description of unionism, because the loyalists had a somewhat more nuanced approach to it. But in terms of orthodox unionism, particularly the DUP and Ulster-Unionist parties, representatives, four broad criticisms. And some of these also were picked up in various academic commentary as well. I'm looking at you, Richard. So first criticism is a criticism of the communal nature of parity of esteem. And it's important in the context of, for example, the agreement, and it's by no means unusual throughout the 1990s, for it to be seen in terms of parity of esteem of both communities, or the other phrase is of the two traditions. So there is very much a communal understanding of it being protected rather than an individual rights kind of perspective. And so one unionist criticism is it should be about individual rights, it shouldn't be about communal recognition. Second criticism is that there's a false equivalence that seems to be required between unionism and nationalism. And that's a false equivalence because unionism essentially is the support for the union, which is the status quo and the constitutional position. And nationalism, while being respected, should not have an equivalence accorded to it. We can talk about that more later on. And the third criticism is that, well, it's okay for it to be applied in the cultural context. I'm worried about it being used in the political context because of this false equivalence argument. But even in the cultural context, there's a danger that the cultural project of nationalism, as it was called, which is protection of the language and so on, seeps into the political, becomes effectively a political statement. So, the idea that the language is simply non-political and the language issue is non-political was queried. Kneecap, where are you? Fourth argument, and this is particularly after Drumcree, or during Drumcree rather, is an allegation of hypocrisy from nationalism. That it's okay, nationalism wants recognition of parity of esteem for their views, but once the unionists start marching down, street supported down, then that is no longer acceptable. You realize I'm not adopting any of these views, I'm simply describing them for the moment. So there's a whole set of overlapping criticisms from unionism broadly. But there is criticism from what I'm afraid, unfortunately, I'm going to call the others. And those of you from Northern Ireland will realize the significance of the term the others as a broad collection. Stretching from civil society through to the Alliance Party. So the main criticism there is a criticism about the two traditions approach. That is that the two traditions approach, parity of esteem between the two traditions, parity of esteem of the two communities, was seen as exclusionary, as not being open for minority rights protections beyond the two communities, and as both encapsulating and making permanent what was seen as problematic by the Northern Ireland conflict. Okay, so those are the critiques. Post-agreement use of parity of esteem. this is by no means in any way a comprehensive list. I'm afraid I just did not have time, and I'm sure others will be able to supplement this list. But in terms of where I see it in terms of policy making, it seems to arise in something like 5 different areas. And the fact that there are 5 and probably multiplying is one of the reasons why I said at the beginning that the term is in constant use, constant contention. So the first use of it is interesting in the context of tracing its use in the British government, by the British government. One of the reasons why it comes into contention is because of Brexit. But even before Brexit, in the paper I've identified an interesting response by Lord Dunlop in the House of Lords, responding to a written question by Lord Laird, in which I think it was 2014, 15, so before Brexit, where basically Lord Laird, in quite a clever written question, as you might imagine, asked what the British government makes of parity of esteem. And the minister, not entirely well advised, I have to say, basically describes it as, well, it's just about fairness between individuals. So gutting it of its radical or more radical communal elements. But it's really after Brexit that the challenge becomes a lot greater about its use and its transmogrification, if that's a word, into something a lot more controversial. And in particular in papers like the Safeguarding the Union paper, where it's used essentially as an idea of why the British government should support the unionist position. It becomes closely allied to the notion of the principle of consent. Obviously, it meets then opposition from those who are arguing, well, what does that make of the other principle in the agreement, which is rigorous impartiality? And Katie has written about that. So there is a sense of evolution, if I could put it that way, neutrally, of the British government's understanding of parity of esteem, particularly in the Brexit context. And so it's not surprising that Kemi Badenoch, when she seeks to, or at least her spokesperson seeks to justify the withdrawal of funding from NECAB, says, well, I'm paraphrasing, what is it about the union you don't understand? We're in support of the union. Why should we fund an organization that is clearly opposed to the union? And interestingly, the notion then becomes, notion then evolves that the Irish government supports nationalism, therefore the British government should support unionism. Okay, so that's in the British government context. A bit more sort of prosaically, the Northern Ireland Human Rights Commission, of course, Bryce, nice to see you, introduces in its advice to the Secretary of State on the Bill of Rights, recognizes that it should be taking into account parity of esteem, and lists various criteria that it adopts in terms of deciding what to include. So it's used there. It's used in the context of arguments about why some of the consociational aspects of the agreement and the structures of governance in Northern Ireland should be revised. In particular, the question about petition of concern and about the essentially duopoly of dominance by nationalism and unionism of the Deputy and First Minister positions. So there's a recent paper, for example, by Column's colleagues at the Constitution Unit in UCL, suggesting that there might be changes made. It's about to be launched, I think, in a few weeks' time, suggesting that changes might be introduced in the consociational aspects. Why? Because of parity of esteem. that is parity of esteem, not between the two traditions, but parity of esteem more broadly defined, and we'll come back to that point. Most recently, I think, it's in the context of the language bill debates, and this is the legislation that was introduced to put into effect the agreement that there would be language legislation, particularly in the Irish language, but balanced with recognition of the of Ulster Scots. In that context, one of the complaints that constantly recurs in the debates, particularly from unionist representatives, is that the differential, particularly differential funding and powers given to the Irish Language Commissioner as compared to the Ulster Scots Commissioner is a breach of parity of esteem. And so we have this rather interesting position where from the late 1990s, where unionist political position was pretty skeptical of parity of esteem, to it now being used as a centerpiece for arguments as to why a different policy position should be taken by the British government. So, lastly, it occurs in the context, at least in terms of how I was able to identify it, it occurs in the context of the question about what majority needs to be achieved in order to pass an Irish referendum proposal. As many of you will know, there's a provision in the Good Friday Agreement translated into the Northern Ireland Act whereby if the Secretary of State calls a referendum and if it were to be passed, then there would be unification. So the question becomes, well, who needs to vote in favor of it in order to pass it? Now, it's pretty clear, and I declare an interest that I was party to the UCL study again in the Constitution Unit about the modalities of the referendum. It's pretty clear that it's a simple majority in Northern Ireland. Whether that's wise or not is a different matter, but in terms of the legalities of it, it's a simple majority. But that has been challenged on the basis that it doesn't recognize parity of esteem, because that would then, on this argument, mean that there should be concurring majorities of both communities. Okay, so one of the reasons why it's quite useful to trace some of these is that there's quite a strong argument, I think, that parity of esteem switches from opposition mode within unionism to it now becoming essentially an emerging unionist veto. Okay, so the legal turn. So, is it a legal principle? We'll get on in a minute to the question about whether it's a constitutional principle, but let's start with whether it's a legal principle. And I'm not assuming it has to be a legal principle for it to be a constitutional principle. I'll come back to that. So is it a legal principle? Well, it's embedded in an international agreement. So at the international law level, yes, it has a legal status. The problem being, of course, that, and this may have been a mistake, I know one's not in these hallowed walls supposed to think that anything in the Belfast Agreement may have been a mistake, but in this context, it may have been a mistake that there is no mechanism for legal enforcement at the international level, or for dispute settlement, or for interpretation in a legal context of the provisions of the agreement. And therefore, yes, it is a legal principle at the international law level, but kind of so what? It's certainly not enforceable. So the question then becomes, in the orthodox understanding of the role of international law at the domestic level, whether it has now been translated into domestic law. The first point to note is that one of the ways in which it was thought that it might be, and this does go back to OPSAL, maybe to the Standing Advisory Commission, but more clearly from OPSAL, that it should be made a legal principle. We saw that in the context of the Belfast Good Friday Agreement, where it's mooted as something that the Equality Commission might enforce alongside the equality of opportunity obligation. So it's quite interesting to think a bit about that, because the requirement to have due regard to equality of opportunity in carrying out functions of public authorities was translated into the agreement, not only into the agreement, but also into the Northern Ireland Act in Section 75. But although the Good Friday Agreement links equality of opportunity and parity of esteem and says maybe there should also be parity of esteem incorporated into the agreement, into the Good Friday Agreement, and then into the Northern Ireland Act, that does not happen. So Section 75, when you look at it, has two requirements. One is due regard with regard to equality of opportunity, and the other is regard to community relations. And community relations then becomes the translation of parity of esteem into the Northern Ireland Act. So it's not parity of esteem, it's good community relations. Not, I think, certainly from those who originated the concept, not the same thing. So it's not then enforceable with regard to Section 75. Second use of it is in the McMahon case. And the McMahon case is this case both in the High Court and the Court of Appeal, which is essentially about the flying of the Union flag in public buildings. The legislation which mandated its use for certain days was challenged. And it was challenged, as it were, from the nationalist side. I'm wary as much about labeling something as nationalist as I am unionist, but you get the point. Broadly, a challenge to the flying of the flag. In that context, part of the legal reasoning that was used, partly in order to avoid a previous decision, Murphy, which clearly upheld the legislation, but not on this ground. The challenge was partly based on it being a breach of parity of esteem. So the question then becomes, for the first time in the judicial review context, are we, the courts, going to give recognition to it as being a legal principle? And the answer is yes, sort of, but not really. And to put that in a somewhat more analytical, legal, doctrinal sense, what it becomes essentially is an interpretive principle, but not a ground for direct challenge. So it can be taken into account in terms of the interpretation of the Northern Ireland Act, for example, and of legislation, but not as a self-standing ground of review. So yes, it's an interpretive principle, and Tom, you've picked up on that in your article in the Constitutional Law blog, and that's right. It is an interpretive principle, but since then it has not been used, even as an interpretive principle. So I've described it as the dog that didn't bite, in the sense that there were several occasions in various judicial reviews where it might have been used and it was not used. And I suspect my colleagues at the bar basically came to a conclusion that it wasn't worth the candle to try to push it. Now, that may have been right or wrong, we can talk about that, but that's the legal position so far. It's there as an interpretive principle, but in fact has not been used. So it might have been used in the D'Souza case, which is the question about Irish-British citizenship issues, and also in the McLean case, which was a challenge to the agreement that the Conservative Party had with the DUP over the confidence and supply agreement after the 2017 general election. That was challenged as being contrary to parity of esteem, linked interestingly with rigorous impartiality, initially it was put as a ground of review, and that was dropped before it came to the courts. and it was dropped clearly because of internal advice. I was not involved in this case. I know nothing about the internal operations of it, but I would suspect it was dropped because it was likely if it was going to be run and you lost, it would increase costs. A costs award. By the way, in McLean case, the Court of Appeal awarded costs against the individuals involved because of the perceived weakness of the argument that was being presented at the time. I suspect the legal advisors thought that adding in parity of esteem was probably going to add to the potential cost order against them, because the English Court of Appeal, I suspect, was going to be unsympathetic to the argument. Now, and then we come to the Identity and Language Northern Ireland Act, 22. Now, in that context, and this is for the first time, a parity of esteem now becomes a legally operational principle. So this is the relevant part of the Act. Now, as far as I know, and I'm subject to correction on this, of course, this particular provision has not been yet brought into force. Now, it may have been brought in the last few weeks, but not so far as I understand it. My trusty Westlaw source tells me that it's not in force. So what does it say? Well, a public authority must, in carrying out its functions, and this is very much Section 75 territory, it's the same kind of framework provision. Public authority must, in carrying out its functions relating to Northern Ireland, have due regard, again, Section 75 language, to the national and cultural identity principles. What are they? Well, these include the principle that public authority should encourage and promote reconciliation. Interesting recurrence of the term, previously used in the context of the Legacy Act. Tolerance and meaningful dialogue between those with different national and cultural identities, with a view to promoting parity of esteem, mutual respect and understanding and cooperation. Now, interesting in this context, because the way in which the reference to a person's national and cultural identity is defined is with reference to a person's religious belief, political opinion, so far Northern Ireland, or racial group. Right? So remember we talked about it in the context of parity of esteem between the two communities, between the two traditions. This is now an expansion, and a significant expansion, because it's now racial groups. So this goes beyond, clearly, the original drafting, at least, leave aside intentions for the minute, drafting at least, which was confined to the two traditions. Okay. So there is a question that I suspect will, if this is brought into effect, that will arise as to whether the idea of promoting parity of esteem is justiciable. Now, you may think, well, it's obvious it's in the statute. Of course, it's therefore going to be legally interpreted. Not so fast. Not clear that it's going to be justiciable. And I suspect that some in government are already developing arguments as to why it should not be justiciable. But we shall see. But that's where parity of esteem is likely, if it comes in, to be subject to serious judicial consideration for the first time. Okay, so let's turn then to the framing of this conference, which is parity of esteem as a constitutional principle. Really interesting question. I mean, partly because it raises the question as to what exactly a constitutional principle is in the British constitutional tradition. Not an easy answer to give. So we might think, I don't know, parliamentary sovereignty, clearly a constitutional principle. Fine. Equality, well, no, the courts have said it's not a constitutional principle. Not least in a case that I tried to run, where I was slapped down significantly. And Colm has written about that kind of issue, and I think you're equally skeptical about it as a constitutional principle. So there is a question here about how you define constitutional principle in the British context at all. Leaving that debate aside for the moment, can we say that parity of esteem is a constitutional principle? And here, obviously, there's a critical distinction between what I'll call the legal constitution, and Colin has written about this. He's not here today for me to thank him. A distinction between what might be called the legal constitution and the political constitution. Now, for the reasons that I've said, I doubt that it's a legal principle in the sense of a legal constitutional principle. Can't see that. Is it a feature of the political constitution? Is it a political principle that can be regarded as a constitutional principle? I'm fairly skeptical of that also, not least because it's very difficult, as we'll see in a minute, to pin down what exactly it is. There is clearly no consensus about it. And to the extent that we might think that one of the ways of recognizing constitutional principles is through notions of convention and a degree of consensus, like on parliamentary sovereignty, for example, there is no consensus as to its meaning currently that I can identify. And I'll talk a bit more about that in a moment. The problem, therefore, about whether it's a political principle of constitutionalism is, I think, as difficult to assert as it is to assert that it's a legal principle of constitutionalism. Again, the question is not, should it be? The question is it? Okay. So I'll come now to my final set of thoughts. So my wife, I have to say, is a biologist, so she talks in terms of taxonomies and things, and I'm afraid that language has crept into my own thinking. Usually, she says completely inaccurately in terms of how it should be used, but I'm going to use it anyway. So what I mean by a taxonomy here is what are the features of the concept that we can identify? So the first is turning to a sort of dictionary approach. There are two concepts in play here. One is esteem and the other is parity. And parity we can think of as broadly about notions of equality. Sometimes, I have to say, termed equity, which I always hate, because it's one of these other kind of weasel words. Let's think of it as in terms of equality. But equality of what? Equality of esteem. Now, esteem, in my regard, in my understanding, is basically respect. But it's more than that, isn't it? It's something is highly regarded. Something is valued, not just tolerated, valued, not just respected, valued. So in this context, then, there's an idea of equality of respect and equality between two sets of aspirations, treating them as equally respected, equally valued, equally to be regarded as deserving. That's quite a tall order. So it's interesting that for example, in the in the Anglo-Irish agreement, parity of esteem is not used. It's termed, instead, there is the notion of respect of the two traditions. Now, respect, it'd be nice to settle for respect, maybe, but that parity of esteem goes way beyond that in terms of expectations. And the question is whether it raises expectations that are unfulfillable. I'll return to that in a minute. Second aspect of the official use of parity of esteem is that it's in the context of the two traditions, two communities narrative. It's possible to kind of read out that narrative and just sort of, you know, it's about parity of esteem, yeah, and forget about the qualification, but textually that just does not stand. In terms of the way it's been used in all of the official documents, it's parity of esteem of the two traditions. And we can like that or not like it, but that's the position. And what that means, therefore, is that both of the two aspirations of the two communities should be valued equally. Third aspect of it that I think is quite important here is that sometimes parity of esteem is used as about minority protections. And certainly from the SDLP point of view in the 1990s, whatever the position now is, I'm not quite sure, it was not seen as an aspect of minority rights protections. Indeed, there is a pretty clear statement by Dennis Bradley, who was one of the originators of the term in the 1991, which says, and I'm quoting here his statement in the Irish press in November 1994, saying, "I am not an ethnic minority. Parity of esteem means we are Irish citizens living in our own country. Our rights are not going to be determined by what unionists concede to us." Now, this may seem a kind of, well, dancing on the head of pins. What's the difference between this and minority rights protections? And the answer is quite a lot. Any of you who are familiar with discussions in Bosnia-Herzegovina know that not being regarded as a minority is very, very important. And the term there is constituent peoples. Effectively, this is the argument that's being applied here, that the Irish nationalist community are constituent peoples. And therefore, this is not minority rights protection language. So to, as it were, put it into the minority rights camp is to misunderstand at least what was intended by those who originated it in the early 1990s. Fourth aspect of the official use is the extent to which it's applied to each of the four significant lines of division that Patrick Mayhew identified in his speech of December 1992. And a very interesting speech, well worth revisiting, quite a thoughtful speech, where he says basically that there are four different fault lines. There's a fault line of national identity, there's a fault line of religious traditions, there's a fault line of cultural traditions, and there's a fault line of socioeconomic divisions. And that seems to me entirely accurate. What's interesting about parity of esteem is that one time or another it's applied to all of those. So for example, to take the one that may not seem immediately clear in terms of socioeconomic divisions, the white paper that was published in 1998 on equality legislation defines it in the context now of parity of esteem. And that's all about socioeconomic divisions, particularly fair employment. So therefore, using it in this binary sense of referring in these contexts to the two communities or two traditions narrative, it's seen as a useful way of viewing each of those sets of divisions. So it essentially functions as a kind of unifying label for the grouping of these different things all together under this umbrella term. Again, I'm simply describing this. Whether it's wise or not is another matter we'll come back to. Fifth point concerns the extent to which parity of esteem can be seen as reflecting a prior intellectual tradition. Now, there are, Simon has pointed this out, several other uses of parity of esteem elsewhere, whether it's in the context of education, as we've said, or in the context of Prime Minister, gosh, name escapes me, Theresa May, where she talks about parity of esteem between, in the health service, between physical health and mental health. uses it in those contexts. And there's a kind of equivalent set of intellectual traditions where it's used in the context of multiculturalism, for example, right? None of that plays out in the context of the development of it in Northern Ireland in 1991 following. It just isn't there. And so it's quite interesting that there's simply no evidence that that grander intellectual tradition, which might have been drawn on, was drawn on. There's no evidence of that at all. Except potentially in the Uppsala Commission, but as we've seen, that was popularizing, but was not the source. So it's interesting that one of the negotiators, Sean O'Geen, several in the audience know well, when he was asked to describe what he thought Parity of Esteem was about, he talked about the OK Corral. And those of you who are not familiar with the OK Corral, this is one of the abiding myths of the frontier, right? In the US context. And he said, basically, it's all about equality. And he quotes one of the characters in the OK Corral. This is not Habermas. This is very basic understandings. Sixth point is to emphasize another of Sean O'Geen's answers. Sorry, he was one of the chief negotiators from the Irish side. When he refers in the same statement to it signifying a proactive equal treatment. And this point's important because it assumes that there is an activist state involved. So in other words, if parity of esteem means parity of respect, of more than that, of valuing, and that this is a principle of governance, then you need an activist state. That causes problems. The seventh aspect of it is whether it is a bridge between the two communities. Now, I think as originally it was intended to be, and I think in good faith, it was intended as a common concept that could be seen as applying equally to both communities, both traditions, that however much we disagree with each other, at least we can agree that we should accord each other parity of esteem. And so from that point of view, it's a bridge concept. And I want to suggest that as it's developed over time, it's not a bridge concept. Now, that may be fortunate or unfortunate, depending on your taste, but I think it's now, it would be heroic to argue that it can survive as a bridge concept. Hence my point about the unionist, more recent use of it in order to counter certain, as they would see, nationalist moves, rather than as a bridge. The eighth and last point that I want to make, and I'm conscious that I have 2 minutes to go, but I will end on time, is that to think a bit about why it can't function as a bridge, in my understanding. So part of the reason, I think, is because not treating parity of esteem as a singular concept, but rather seeing it as a group of as one of a group of concepts. And the problem that seems to me to arise is that parity of esteem is nearly always linked to some other concept. So unionists, I think, link parity of esteem to an expanded conception of the consent principle. Not just a consent principle in terms of, the narrow questions of legality in terms of how the Northern Ireland Assembly works, where it should be seen to be operating, but much more generally in terms of the consent principle, meaning the two communities have to agree to everything, anything. So if you link parity of esteem to the consent principle in this expanded form, then that's a unionist conception. On the other hand, and that's not how nationalists use it. On the other hand, nationalists link parity of esteem to an equally expanded conception of rigorous impartiality. So the notion that the state should be neutral on all things, particularly between the two traditions. So if you link parity of esteem to rigorous impartiality, then that just is, I think, incompatible to the understanding of it as linked to the consent principle. Then thirdly, the others, sorry about the term, but you understand. Many of the others, I think, are here today, so my apologies. Queen's generally has an overrepresentation of others at these occasions, but there we go. The others in this context tend to use parity of esteem, when they use it at all, as linked to pluralism and to diversity. And again, that's just not compatible, I suspect, with the two previous uses of it. So my suggestion then is that in most contexts, those who use it basically talk past each other. Now, in some cases, talking past each other is a useful ploy. And here we get into creative ambiguity. So in negotiations, there is a role for people talking past each other if they can get to an agreement in the end. That's fine. That's not going to work anymore. And so I suggest that we see here the limits of creative ambiguity. In other words, that creative ambiguity has come back to bite us. Thank you. Sure.
So thanks so much, Chris, for that. I can see that there's already a hand raised. Now, we don't have a roving mic, so... Oh, we do. Good one, Katie. Oh, you've got it there. So, yeah, first question there, please.
Thank you, Tom, and thank you, Chris, for a very impressive lecture. Impressive for a number of reasons which don't surprise me, but which are very helpful, I think, in terms of clarity about where the idea has come from, what it's applied to, and what it means. So thank you very much. I look forward to reading the paper. I've got an observation which I hope will be interpreted constructively about the debates that are going to happen in this important event today and tomorrow. So this is a kind of constructive, unambiguous way forward. And I suppose my point, which I'd like your view on, is really that the question we should be asking is, what unique work does parity of esteem do? And I share your skepticism. I mean, esteem, as you rightly say, Chris, it's not just about respect. It's respect and admiration. And that's a very different thing. And it seems to me, if we think of past, present, or future, there are reasons to be skeptical about how much it uniquely does. So the main drivers of the peace process in terms of getting formally violent actors to cease to be violent did not depend on parity of esteem, power sharing, the containment of violent groups so they changed direction, human rights protection, the consent principle. None of that was dependent on it. And it's interesting that someone like yourself who's expert in these things hasn't really thought about the concept, even though you have thought a lot about how peace came in the North. So in the past, I'm not sure it was that useful. Presently, you suggest there are reasons for being skeptical about what legal or constitutional work it currently does. And in the future, if we were in a putative United Ireland independent of Britain, if you were applying it to different traditions, are we really going to expect the Irish state to say that they equally admire those of their new citizens who think that empire is actually preferable to anti-imperialism, that monarchy is actually preferable to the republic, that actually the special branch in the IUC deserve equal admiration to the people who fought against the UK? Is that really a coherent thing for the state to do? So this is my question is, do you think there's anything that it uniquely does that we need it? Because a lot of the words which are really central, toleration, understanding, dialogue, reconciliation, even respect, you could leave the parity of esteem out of it and still have all of that. So my question for you, and I suppose my question overhanging the next couple of days, is what unique work do you think parity of esteem might do? Because without it, we're surely better off leaving it out.
So the temptation to be glib at this point is almost overwhelming. The glib response is that the only function it really plays is that it's an additional battering ram that each side uses against the other. And that's that observation is not new, right? So Mark Hennessy and I can't think who his other author was, in 1998 published a piece for Democratic Dialogue. Robin Wilson published a piece for Democratic Dialogue called "With All Due Respect," and in that context, they say even by that time it had become a battering ram, and I suspect it really has not changed since then. So I can't see, and there are so many other battering rams that we use in these contexts that I'm not sure even we need it for that purpose, right? If it wasn't there, we'd invent some other battering ram, yeah. And that's because this is no, terribly enlightening statement. There is profound disagreement. And therefore the notion that esteem, and I come back to your point also, that we should esteem the other side is quite a claim. I mean, we might respect them just about, and that would be nice, but esteem just seems to require something additional and extra that I think we're agreeing on is potentially not just potentially unattainable, but maybe something we shouldn't even try to strive to, in the sense that it creates expectations that, as I said earlier, I think are probably unhelpful.
Anyone else? Lady by the wall there. Oh, excuse me.
Sorry, there's 2 points I'd like to make. First of all, what parity of esteem, you referenced John Hume, and John Hume always said that dialogue threatens no one. So I suspect that his idea behind that was that you have equal voice on both sides of the community. That's point one. And the other point I was going to make is that you referred to it as a concept of creative ambiguity. I think that's an interesting concept, and that concept creates an open political space for goodwill and mutual understanding.
Yeah, no, I think that's exactly how it was intended. Absolutely, I think you're absolutely right that that's how it was intended, and I think in good faith, as I said earlier on. But it promises more. So it promises more than dialogue. And, we had a very interesting conversation a few days ago about the thought of John Hume and indeed of David Trimble. And by the end, both of them were committed to genuine dialogue, I think. But parity of esteem is not necessary in order to support dialogue. And it promises more. It promises that in entering the dialogue, or at least in exiting the dialogue after the dialogue's taken place, that something extra is delivered. And this is the conversation that I've just been having with Richard. So I think that it was intended in this way as a bridge, and the bridge, therefore, in order to encourage dialogue, in order to create a common space where they could meet and genuinely engage with each other. But I think that parity of esteem was one of the ways of capturing that idea, but I think it went beyond that. And I think it was intended also to go beyond that. In terms of the creative ambiguity point, again, you're absolutely right that one of the ways in which these terms can be useful is, I work on notions of human dignity. Human dignity is that kind of phrase also, where at least you can get people into the room to talk about what it means. They may not end up agreeing with what it means, but at least you're on a sort of common, the table is there at which you can both sit down And parity of esteem, I think, can operate in that way. And I think probably did operate originally in that idea. But I think now the problem is that it's lost, a bit like human dignity, it's lost its kind of honeymoon period. Right? There are people now who think human dignity, like parity of esteem, is not necessarily a good idea. And so it loses its capacity once we examine it in detail, once you forensically take it apart. And once you get extended opposition to it, it loses that kind of mechanism. It loses that kind of function, as I understand it. So, in short, yes, I agree. It could have that capacity that you've described in terms of encouraging dialogue. I don't think it does that now.
So our friend in the green shirt, I think.
First of all, thank you for your presentation. It was really, really insightful. My question was, when you talked about how the parity of esteem has expanded to include racial groups, is there a way to evaluate how successfully this has been done in sort of modern-day Northern Ireland?
Well, you may be asking one of two different kinds of questions, right? The first question is, has the concept of parity of esteem as a legal principle operated in the context of racial minorities in Northern Ireland? And the short answer is no, it hasn't, because this is the first time it's been introduced in the legal context. I could say also, but it's way beyond my brief, that to the extent that it may have played a role politically in terms of relations with ethnic minorities. First of all, I haven't seen it in that context very much. Maybe it is, but I haven't seen it. And I would say, however, in broad terms, that the state of relations with ethnic minorities and the state of racial equality in Northern Ireland is not exactly stunningly successful. So I look forward to, potentially the use of parity of esteem between racial groups, where it has not yet lost its kind of honeymoon period, because this is the first time we've seen it. So it may, in that context, have more, interestingly, more bite, simply because it's a new concept in that context.
I think we've got time for two more. So I saw Ewan and then I saw the gentleman here. I do see the lady here now, so let's say three more. So, Katie, will we go for Ewan first?
Thank you very much. That's fascinating, Chris. Just one question quickly. You focused on the duty to have due regard under Section 75. Do you think maybe the principle bites harder on Section 76 and the duty not to discriminate on grounds of political opinion?
Interesting question. So the question was, leave aside the analogy with Section 75, the Northern Ireland Act. Could parity of esteem play a useful role in the interpretation and application of Section 76, which is the provision that deals with non-discrimination on grounds of political opinion or religious belief in the exercise of powers in governmental powers in Northern Ireland? I think the short answer is maybe, but it's more likely to play a rhetorical role than an actual legally substantive role. In other words, coming back to sort of Richard's earlier point, yes, it has a potential implication, connection, and indeed that was, in fact, drawn attention to in the white paper in 1997 on equality, but it hasn't played any role since, either in the Section 75 context or in the Section 76 context. I'm not sure we need it, other than rhetorically.
Thank you, Chris, for the paper. So many hooks, it would be rude not to bite at least one of them. On the Language Act and the building in of a Supreme Parliament saying that due regard has to be had by executive bodies to parity of esteem, how do you wish that away? You said in the context you could see an argument being made that would sideline it there. Now that we have this new invocation of parity of esteem, I don't disagree with any of the rest of the problems that you're casting for it, but now that it's there, how do we get around it?
You mean, should we want to get around, should a malign actor want to get around that? Yeah, no, it's a good question. Two ways, and I'm slightly cautious about this because I'm now going to give you two arguments as to why a malign actor could undermine it. Right? Needless to say, there are potential rebuttal arguments to each of these points that I'm going to make. The first way, in terms of wishing it away, and by the way, I'm not trying to wish it away. I'm simply trying to be analytical about it. The first way of wishing it away is that it's a non-justiciable concept. So there is current litigation, and I have to declare an interest. I'm involved in it as legal counsel. There's currently litigation where there is an application, an attempted application of Section 75(1) on equality of opportunity, due regard duty, to the budget, to the Northern Ireland budget. And in that context, and I'm not disclosing anything that I shouldn't be because it's in public domain, the argument has been made by representatives of Department of Finance that that concept is not judicially reviewable. That is, it cannot be decided on by the judges in terms of its meaning or application. That's what I mean by a non-justiciable principle. And so if you apply the logic of what's being argued in the Section 75 context to this context, then there is equally an argument that this set of concepts are basically concepts of political utility rather than legal utility. And therefore, it's basically up to the political system to enforce this rather than the legal. Yeah, that's the first point. The second point in terms of a way to get rid of it, should one be minded to do it, is to go back to the McMahon case. And you remember in the McMahon case, this is the case dealing with flags that I mentioned earlier. The current, who's now the current Chief Justice, Lady Chief Justice Siobhan Keegan, in the High Court, said basically, and she had agreement from the Court of Appeal, that the use of parity of esteem in the, and you remember this, in the Good Friday Agreement was embedded in a whole paragraph. And you couldn't separate out the different elements of that paragraph sufficient to be able to apply just one of those concepts, which was parity of esteem. Now, I mean, interestingly, in the context of the Language Act, it's also embedded. So it's embedded in, with a view to promoting parity of esteem, mutual respect and understanding and cooperation. So if you were to apply strictly the approach that current Lady Chief Justice Keegan adopted in McMahon, you could say you can't separate out parity of esteem out as a separate principle. It has to be embedded, and in embedding it, it therefore loses its more radical edge. That may be good or may be bad, but it's an argument that might be floated.
Hi, Chris. I suppose my question is actually not to do with this jurisdiction, strangely, and the interjurisdictional issues there be over parity esteem, but the use of that, going back to some of your history, which I think is really, you've made a really, really important contribution in this whole debate, is internationally, in other regions of conflict, where people are suffering under dominant regimes that are really oppressive and excluding groups of people from that in abuse of power. How does it sit within that context?
Well, I mean, thanks, Brona. I mean, you rightly reminded me when we talked about this last week, right? That you use it in the context of your advice giving and engagement in other countries, yeah, in terms of other groups. And so, you know, thank you for that. So it clearly, interestingly, may play more of a role outside Northern Ireland, ostensibly basing itself on the Northern Ireland experience, than it does in Northern Ireland itself. And that's a potential paradox. I mean, it's a wonderful paradox that our developments in Northern Ireland are seen to be somewhat more exportable than actually applicable in Northern Ireland itself. And if that's the case, then great, super. And so, you know, my answer then to Richard's question, what functions might it play, could well be modified by saying, actually, it plays a role outside Northern Ireland more than it does in Northern Ireland. Beyond that, I can't really be tempted because I haven't done an analysis of its use either internationally or in other domestic contexts. I think that'd be a really interesting thing to do. And you know, if there are any graduate students around, that's a very, very nice project to talk about the exportability of concepts developed first of all in Northern Ireland. So that might be quite an interesting study, but I'm afraid I'm not able to answer it myself.
Okay, well, thanks so much, Chris, and thanks, everyone. I know there's more questions, but we both are and aren't stuck for time. We're stuck for time in the very short term, but we have today, we have tomorrow as well, so please do make a note of your question, and I'm sure we can come back to it. There's coffee in the room behind. We are scheduled to start again at 11 o'clock, but I've got no problem with eating into lunch later on, so why don't we come back at 10 past, quarter past 11 for session 2. So thank you once again, Professor McCrudden. What a fantastic way to start the conference, and the discussions will continue. Thanks, everyone.